पहले जो विड्रॉल वाले इसको खत्म करें। विड्रॉल वाले कौन करें?
Orders for withdrawal item 1 CMP 40 of 2025.
CMP number 40 of 2025 with IA number 4329 of 2025.
753 withdrawn.
IA number 7538 of 2025. Counsel for the petitioner submits that interrogatory application has been filed for withdrawal of this case. Any objection? Counsel for the respondent has no objection to the prayer for withdrawal. Accordingly, this petition is dismissed as withdrawn. IA number 7538 of 25 is disposed of. IA number 4329 of 25 which is a petition for early hearing of the case is also closed. Next.
Item 2 CMP 41 of 2025.
Same order. This IA, any objection, respondent? Petition has been filed for withdrawal. Same order. इसका IA number है 7539 of 25. इसमें अर्ली हियरिंग का IA है IA number 4328 of 25. Same order.
This case item 6 second appeal 153 of 2018.
Yes, madam, are you appearing in this case or not? Madam Patro, are you appearing in this case? Your case has been called up. Yes, are you?
The list of judgments and the arguments written on this.
Give us the facts of the case, the timeline.
In this matter, yesterday mentioning was made making certain aspersions against me.
You don't bother about it. I don't buy any aspersion against anyone.
Because I find I filed document before a lordship.
We don't bother about it. You just
Having getting this sort of instruction, making so many allegations against the court below also.
We just don't bother. You don't bother yourself about it.
Yes.
वो जो बोले हमको सुनाई नहीं दिया.
I am having bereavement in my family. I am unable to read the cases.
On the last occasion when this case was taken up, I remember that we had said that this case, if it is mentioned, you also said that it will be argued.
No, I will have to come out of this case because certain aspersions have been made against me who has been practiced for 60 years.
In the memo of opinion.
No, this is in hearing, in submissions.
No, nothing has been recorded.
No, my lord has not recorded.
No, I don't
but
record
I
all
heard
this.
it.
You see, there are so many things being said. We don't record anything. You don't need to worry about it. Yes,
So, my lord, I am not in a position to read the case. I will have to come out of this case also. I am having bereavement in my family, not mentally, physically well. So, my lord, I will not be in position to attend this case, do this case.
No, it is one thing to say that you are seeking adjournment. It is another thing to say that you will not be able to do this case. What is your instruction? You have been instructed to argue. You are the senior counsel. Every day you must have been instructed to
I have not read
argue.
the brief, my lord, because of my bereavement in my family.
Okay. So when do you want?
संडे को हमारा घाट वगैरह हो जाएगा.
कब के लिए रख दें?
संडे के बाद में.
संडे के बाद. ठीक है, स्टे कर देते हैं. ठीक है, he is seeking time, we will stay the entire execution. चलिए बताइए और क्या चीज stay करना है? I will record that he is not in a position to argue, therefore we have to stay. There is nothing more as to बताइए.
My lord, the proceeding of the execution proceeding has to be stayed, ma'am.
Yes, yes, we will stay there.
As because rate of delivery position has.
You see, the case was mentioned. The counsel is not ready. A counsel who is seeking time, उसके against में इतना order तो बनता ही है ना कि stay हो जाएगा execution. आपको remedialist थोड़ी कर
Execution
देंगे.
proceeding, they are not party.
Maybe they are not party. We don't bother about it. देखिए second appeal number 153 of 2018. Counsel for the appellant is present. The learned counsel for the appellant, the learned counsel for the respondent. Senior counsel for the respondent, Mr. M.K. Laik, assisted by M.S. Manjushri Patra, submits that he is not in a position to argue the case at all on account of bereavement in his family. He submits that the matter we posted on आप ही date fix करिए, हम नहीं date fix करेंगे. बताइए. You choose your date.
15th of July.
He submits that the matter be fixed on 15th of July so that he may also get ready with the brief and argue the case. The learned counsel for the appellant has drawn the attention of this court to the order dated 28/4/2025, wherein it was observed that no adjournment will be granted on account of absence of the respondent. The learned counsel for the appellant has also submitted that the executing court is proceeding in the matter, and since the respondents are seeking time for on their personal ground, the execution proceeding may be stayed, and he submits that for which IA number 407 of 2025 has been filed. In view of the face with a situation where the learned counsel for the respondent has personal difficulty in arguing this case, and at the same time the appellant is aggrieved by the proceeding before the executing court, and a stay petition has also been filed, the matter is directed to be posted on 15th of July 2025 at the request of the counsel for the respondent, and till 15th of July the proceeding of execution case number 7 of 1997, in which the appellant has filed miscellaneous case number 7 of 1997 under order 21/97 of CPC shall be reinstated. Communicate through fax.
Grateful.
Chalo. आइए डिस्पोजल.
I stand disposed.
अच्छा.
Item 4, second appeal 231 of 2018.
The appellate was the plaintiff under the suit for eviction on the ground of default. We have not succeeded in both the courts.
What is the ground?
On the ground is what's the question of law, the defense was struck off. Can you have a look at the question of law? It was framed on 7th of February 2023.
Can you read the ground?
Whether the learned first appellate court has
Yes, yes.
First appellate court has committed a grave illegality by considering the pleadings and evidence of the defendants, though the same was struck off by order dated 16/2006 entitled Eviction Suit number 86 of 91, consequent upon the failure of the defendants to deposit the rent in respect to the suit premises in the court in view of the principle of law settled by the Honorable Supreme Court of India in Paragraph 24 in the case of Modular India versus Complex India reported 88 for SCC.
When was the defense struck off?
It was 16 to 2006.
16 to 2006.
That is before the trial court.
What was the stage of the case?
Sorry,
What was the stage of the case at that point of time?
where the WS was filed and section 15 they failed to comply.
Just a minute. Then how the evidence of defendant was taken?
There was no.
It is mentioned. Illegally considering the pleading and evidence of the
So
defendant.
that is the only point, no, that whether they evidence. Oh, it was diffused. It was diffused. So that has to be expunged. That's how it was to be expunged.
I don't know. Place the judgment. It's a substantial
yes,
question of law.
Yes, that's
Suppose there is an order for payment of rent, last paid
Yes.
rent under section 15, and the suit continues for 10 years. Right?
and he has to
Person
pay.
is going to pay,
Yes.
right? And at the fag end he defaults. After the closure of the even defense evidence, then the entire defense evidence has to go.
Yes, which will be the
Then under such circumstances, if we see that the entire defense evidence has to go, then at the same time we have to see that whether irrespective of the defense evidence, the
Correct.
judgment will sustain or not.
Yes. You know,
That has to
then-
be seen.
Yes, yes,
That is a consequential part.
Correct, absolutely. That second
Mr.
part is absolutely that's the question.
Which paragraph 24?
Paragraph is
22.
24 records.
This is something, this particular observation is in connection with the circumstances where the defense is struck off at an earlier stage. Suppose the defense is struck off at a later stage.
I don't find any distinction in law. The defense, if it is struck off at any subsequent point of time,
So therefore all the evidences are to be discarded.
except for the cross-examination on the point gone off from the.
That's right, cross-examination is right.
Because kindly
But-
see paras 19 of this judgment. Because what?
Let us, can you read this judgment? What was the, at what stage the defense was struck off? I want to know. Read this judgment.
Yes. A somewhat important question as to the nature and scope of rights available to a defendant whose defense has been struck off or calls for determination in this appeal in particular context of West Bengal Premises Tenancy Act 1956. The appeal arises out of the judgment of the full bench of the Calcutta High Court constituted to resolve a conflict in earlier decisions of the same court on the issue. A full bench by a majority of the two, P.K. Bhattacharya so and one so, decided that the matter where defense against delivery of possession is struck off under subsection 3 of section 17 of the West Bengal Premises Tenancy Act. The defendant cannot cross-examine the witness called by the plaintiff excepting on the point of notice under section 13(6) of the said act. The correctness of the view taken by the majority is contested in this appeal. Though the other judges were of the opinion that the issue decided on reference raised substantial questions of law of general importance, they considered themselves unable to grant a certificate of fitness for appeal to this court, since the reference had only arisen on an interim order and the view expressed did not result in a judgment of against which leave to appeal could be granted. Thereupon, the aggrieved party filed a petition for special leave to appeal before this court, which was granted. It is in this manner the issue has been brought up before this court. A detailed factual background is not necessary since the question raised is purely one of law. It may, however, be mentioned that the respondent is in this appeal filed a suit in 1979 on the original site of the Calcutta High Court, praying for a decree directing the defendant to deliver a vacant and peaceful possession of the certain premises in Calcutta, and also for decree of means profit or damages from February 1, 1978 till the date of delivery of possession. The appellant, a company carrying on business at the premises in question, filed a statement denying the averments in the plaint and the claims were made there. During the pendency of the suit, several interlocutory applications were made from time to time, in which orders were passed directing the present appellant, here to refer to the tenant, to deposit certain sums in court. At one stage, it appears that the tenant made an application claiming that he may be permitted to deposit the areas of rent in monthly installments along with current rents. No orders were passed on this application on the ground that the application was out of time. However, it appears that subsequent to the disposal of this application, the defense of the tenant had been struck off under the provision 17(3) of the Act. The correctness of this order striking of defense of the tenant has become final and is no longer an issue. However, it appears that the tenant contended before the trial court, though the details are not available on record, the order dated 17(3) court at worst preclude the tenant only from adducing evidence or a commentary in support of the arguments made in the second statement. It was claimed that it was open to the tenant to exercise his rights, A, of cross-examining the plaintiff witnesses, B, of pointing out to the court the factual and legal infirmities in the plaintiff's case, and C, of addressing arguments on the basis of evidence as adduced by plaintiff and tested by cross-examination on behalf of the defendant. Then counsel for the appellant also urged before us that though the defendant has conceded before the High Court that it would not be entitled to any evidence, the reference being of general question regarding the consequence of a strike-off, we should consider the question in all its aspects and lay down the principles governing such cases. We may start by referring to the provisions of Section 17 of the Act. When a suit for eviction is filed under the Act against any of the tenants on any of the grounds specified in Section 13 of the Act, Section 17 imposes an obligation on the tenant to deposit into the court or with the controller to pay to the landlord all areas of rent due from him with interest within the specified period, and also to continue to deposit or pay the current rent thereafter regularly month after month. Subsection 2 provides some machinery for determination of the amounts to be paid or deposited. In case of dispute, subsections 2 and 2b contain provisions enabling the court to subject to certain restrictions to extend the time for such deposit or payment or allow the deposit or payment to be made in installments. If the tenant deposits or pays the amounts as above, he is protected from being evicted from the premises on the ground of non-payment of rent. Subsection 4. If on the other hand he fails to deposit any amount referred to above within the time permitted, and consequence set out in subsection 3 will follow. That subsection reads, if the tenant fails to deposit or pay any amount referred to in subsection 1 or subsection 2 within the time specified therein, or with such extended time, may be allowed under clause A of subsection 2A, or fails to deposit or pay any installment permitted under clause B of subsection 2A against within the time fixed. Therefore, the court shall order the defense against the delivery of possession to be struck out and shall proceed with the hearing. Before discussing the interpretation of the crucial words of the subsection, it may be useful to set out certain analogous provisions which may have been the subject of judicial consideration. The Withdrawal Act 17 of 1950, which preceded the one under consideration, was somewhat different in its language. Section 14(1) of the Act dealt with a case where the suit was placed on the ground of non-payment of rent. The court could make an order calling upon the tenant to pay up the areas of rent on or before the specified. A sequitur was set out in subsections 3 and sections 4 as follows. If within the time fixed in the order under subsection 1, the tenant deposits in a court the sum specified in the said order, the suit, so far as it is a suit for recovery of possession of the premises, shall be dismissed by the court. In default of such payment, the court shall proceed with hearing of the suit, provided that the tenant shall not be entitled to the benefit of protection against eviction under this section if he makes default in payment of the rent referred to in clause 1 of the proviso to subsection 1 of section 12 on 3 occasions within a period of 18 months. If a tenant contests the suit as regards claim for rejection, the plaintiff landlord may make an application at the stage of the suit for order of a tenant on the tenant defendant to deposit month by month rent at a rate at which it was last paid, and also the areas of rent, if any, and the court after giving an opportunity.
Just that we got the background. Now you come to the final. You can come to paragraph number 6.
On behalf of the appellant, the counsel submits that a tenant or defendant whose defense is struck out is in the same position as if he had filed no written statement in the suit. It is pointed out that the original side rules of Calcutta High Court permit a defendant who is said to be ex parte either by not filing a written statement or by non-appearance to cross-examine the plaintiff witness and to address the court not only that the rules confer a discretion in the court to permit him to have the assistance of an advocate even to reduce the evidence. This is based on the principle that the effect of an order striking of defense can only be that the defendant should not, because of his default, be permitted to plead the positive case which he had or could have put forward in his written statement or substantiate it by reading evidence on his side. This cannot preclude him from putting forward a plea that the plaintiff is not entitled to a decree as he has not proved his case. Thus, it is said he is entitled to do either by cross-examining the plaintiff's witness and thus demolishing the plaintiff's case or addressing arguments either on points of law or even on facts in the light of the plaintiff's evidence as tested by his cross-examination. Even this cannot, it is urged, be an invariable rule. The court should always have a discretion as provided for in the Calcutta High Court rules to relax the rigidity depending upon the circumstances of each case. The position in an eviction petition, it is said, cannot be much different. The counsel urged that it is well established principle, particularly on the syntax, that it is for the plaintiff to satisfy that the conditions set out in the statute to enable him to obtain an order of eviction as strictly. Even when a defendant is said to be ex parte, the plaintiff is not absolved from his responsibility. It is also not necessary for the court in such cases to satisfy itself that the plaintiff is entitled on terms of the statute to be paid for, it is so and so or so and so.
That's
In doing this,
This was the main case.
Yes.
Now, the finding.
Now, all the judgments have been, now your lordships will come to para 19 according to me. Paragraphs, actually not, it should start from paragraph 15 onwards the finding, but 16 there is the reasons come, 16. Page 640. What is the nature of the provision? Lordships.
Para number 16.
That's it. A provision like the one in section 17(3) is a provision in general, which penalizes the defendants for certain defaults of his. As pointed out by the decisions earlier referred to, the court will act with great circumspection before striking out the defense of a tenant under this provision. This court has interpreted provisions like this in syntax to say that striking of defense is not obligatory on the court merely because there is a default and that it is a matter for the exercise of great judicial restraint. But it does not necessarily follow that once defense is struck out, defendant is completely helpless, and his conduct of the case should be so crippled as to render a decree against him ineligible. To hold so would be to impose on him a punishment disproportionate to his duty. The observations made by this court while discussing the provisions of the Code of Civil Procedure and the original side rules of the Calcutta High Court, which deal with somewhat analogous situations, cannot be lightly brushed aside. Those decisions have enunciated a great equitable principle. We are also the same view that the provisions of this type should be construed strictly and that the disabilities of a person in default should be limited to the minimum extent consistent with the requirements of justice. This should be all the more so in the context of tenancy legislation, the main object of which is to confer protection on tenants against eviction by the landlord, unless certain statutory conditions are fulfilled. The provision should not be given any wider operation than could have been strictly intended by the legislature. It has already been noticed that in the Calcutta High Court there has been unanimity on the point that even where defense is struck out, the validity of the notice under Section 13(6) is challengeable. This has been settled view of the court for several years now, which would be inequitable to disturb after such a long time. This type of cases, however, have been sought to be distinguished on the ground that such notice is a condition precedent to the institution of a suit, but cannot perhaps be described as a defense to the suit. This, however, is too tenuous a distinction. For in truth and substance, plea regarding the validity of the notice has invariably to be taken as a plea in defense in such suit. Rule, therefore, is really an exception to the strict application of a rule that a tenant whose defense is struck off cannot be heard at all against a plea of anyone. We agree that the full effect should be given to the words that defense against judgment is struck off, but does This really deprives the defendant tenant of further participation in the case in any manner. While it is true that in a broad sense the right of defense takes it within its canvas all aspects, including the demolition of the plaintiff's case by cross-examination of his witness, it would be equally correct to say that cross-examination of the plaintiff's witnesses really constitutes a finishing touch which completes the plaintiff's case. It is a well-established proposition that no oral testimony can be considered satisfactory or valid unless it is tested by cross-examination. The mere statement of the plaintiff's witnesses cannot constitute a plaintiff's evidence in the case unless and until it is tested by cross-examination. The right of the defense to cross-examine the plaintiff's witness can therefore be looked upon not as a part of its own strategy for defense but rather as a requirement without which plaintiff's evidence cannot be acted. Looked at from the point of view, it should be possible to take the view that though defense of a tenant has been struck out, there is nothing in law which would preclude him from demonstrating to the court that the plaintiff's witness were not speaking the truth, or the evidence put forward by the plaintiff is not sufficient to fulfill the terms of the statute. To us, it appears that the basic principle that where a plaintiff comes to the court, he must prove his case should not be whittled down, even in a case where no defendant appears. It will at once be clear to say that the court can only do this by looking at the plaintiff's evidence and pleading supplemented by such questions as the court may consider necessary, and to completely eliminate any type of assistance from the defendant. In this task will place the court under a great hardship handicap in discovering the truth or otherwise of the plaintiff's statements. For after all, the court on its own motion can do very little to ascertain the truth or otherwise of the plaintiff's argument, and it is only the opposite party that will be more familiar with the detailed facts of the particular case and that can assist the court in pointing out defects, weaknesses, errors, and inconsistencies of the plaintiff's case. We therefore think that the defendant should be allowed his right to cross-examination arguments, but we are equally clear that the right should be subject to certain important safeguards. The first of this is that the defendant cannot be allowed to read his own evidence. None of the observations or decisions cited have gone to the extent of suggesting that in spite of the fact that defense has been struck off, the defendant can deduce evidence of his own or try to substantiate his own case. Secondly, there is force in the apprehension that if one permits cross-examination of plaintiffs witnesses by the defendant whose defense is struck off, procedural chaos may result unless great care is exercised, and that it may be very difficult to keep up the cross-examination within the limits of the principles discussed. Under the guise of the cross-examination and purported demolition of the plaintiff's case, the defendant may attempt to put forward pleas of his own. To perceive quickly the difference between questions to put out to elicit a reply from the plaintiff which may derivate from his own case and questions to put out to substantial pleas of defense which the defendant may have in mind, and to restrict the cross-examination to its limit will not be an easy task. We think, however, that this is a difficulty of procedure rather than substance. As pointed out by Ramendra Mohan Datta J, this is a matter to be sorted out in practical application rather than being laid down in a hard and fast rule of exclusion. A third safeguard which we would like to impose is based on the observations of this court in Sanjay's case. As pointed out therein, the essence of the matter in all such cases is that the latitude that will be extended by a court to the defendant in spite of having his filed a written statement should not cause prejudice to the plaintiff. Where the defendant does not file a written statement or where he does not appear or contest the plaintiff's proceeds on the basis that there is no real opposition and contents himself by letting in just enough evidence to establish a prima facie case, therefore the court should ensure that by permitting the defendant at a later stage either to cross-examine the witness or to participate in the proceeding, the plaintiff is not taken by surprise or gravely prejudiced. This difficulty, however, can easily overcome in practice because there is a wide discussion with the court that it is always open to the court where it believes that the plaintiff has been misled to exercise its discretion to shut out his law and to regulate it in such a manner as to avoid any real prejudice to the interest of the plaintiff. An objection to our above conclusion has been raised on the basis of the provisions of Order 7 of the Code of Civil Procedure, Rules 1, 5, and 10 of this order have been recently amended by the Adjournment Act. We find nothing in these rules which will support the contention urged on behalf of the respondent. Rule 1, this according to me can be skipped.
Yes.
Para 24. For the above reasons, we agree with the view of Ramendra Mohan Datta, acting CJ, that even in a case where defense against delivery of possession of a tenant is struck off under section 17 for their defendant, subject to the exercise of appropriate discretion by the court on the facts of a particular case would generally be entitled to cross-examine the plaintiff's witnesses and to address arguments on the basis of the plaintiff's case. We would like to make it clear the defendant would not be entitled to read any evidence of his own, nor can his cross-examination be permitted to travel beyond the very limited objective of pointing out the falsity or weakness of the plaintiff's case. In no circumstances should the cross-examination be permitted to travel beyond the legitimate scope and to convert itself virtually to a presentation of the defendant's case either directly or in the form of suggestion.
Para 18 talks about further participation.
Correct?
So if the evidences which have already been led
No, that
and the tenant is not in default, then
When it
under
was-
such circumstances.
But it is the question of not. It is the question of striking of the defense before the
So
cross.
therefore para 18, you just read the opening sentence of para 18. And this has to be certainly read with paragraph number 16, which casts a discretion
No,
upon the
what further participation means, Manoj?
further participation.
Manoj, the further participation is in the arguments to cross-examine only or to a limited to that means.
The point is the evidence which has already been brought on record.
It
What will
have
happen to that
It will have to
evidence?
be brushed aside. It can't be looked into. That's the point. It can't be looked into. It will only be looked into for the purpose of demonstration.
Let us see the order by which you were directed to pay the rent. Which is that order?
May I give the copy also? I have copy.
Yes, sir, आपके
29/7,
copy
29/7/2005. 29/7/2005.
Can you read the order?
Both parties are represented through their respective lawyers, heard learned counsels for both the sides on the petition under Section 15 BBC Act filed by the plaintiff. In the petition under Section 15 BBC so and so, dated so and so, the plaintiff has claimed the earlier rent from May 2084 onwards, but has sought directions to deposit of this amount as well as before as well as future rent at rupees 250 per month. In his objection filed on 25/11/98, the defendant contested the claim stating that he is not a tenant of the plaintiff but that of Hasina Begum, and being no relationship of landlord and tenant between the two questions of deposit of rent arises. Heard the counsel of both the sides and perused the record of the case, the defendant's counsel contended that he is not a tenant of the plaintiff but that of one of Hasina Begum. The defendant had entered into the
Okay, what is the final outcome?
final outcome.
What is the final
He was
result?
asked to deposit.
Wait, let us see the period. Let us see the period. You were claiming rent right from.
No, but that is irrelevant.
No, let's see what is it.
Kindly covers 3 years
You
prior
were
to-
from May 1984.
Yes, but I got only from 3 years prior to the date of
Let's see,
filing of this
let's
one. At the next page, no? From 4/10/91 at the rate of 250, and then current rate.
Just a moment. Three years prior to the date of filing of the suit, that is 4/10/91, at the rate of rupees 250 per month, and pay the current rate.
And that order was challenged before the Honorable Court, Lords.
What happened there?
Lords, you may kindly see order passed by you. You may kindly see order passed by this Honorable Court. He is the claim the land on
Just a पढ़िए ना order पढ़िए.
अच्छा, but-
So he is not defending his case with regard to holding number 331. The order of eviction is in connection with withholding.
Holding number 331, I am reciting holding number 332.
No, the decree is on that 381. So that's
332.
Degree is on 332.
331.
331.
331, but I am reciting in 332. That plot was purchased by me, that is exhibit E Lordship, by virtue of registered sale deed in the year 2010
That
Lordship.
cannot be
That is a
decided here.
separate thing, that cannot be
Yes,
decided
yes,
here.
yes,
The
absolutely
point
right.
is that then under such circumstances, even if your defense is
Then-
struck off, you are
Yes.
not concerned.
Yes, not concerned.
So therefore, even if you are evicted from 331, you are not concerned.
Yes, not concerned. Not concerned. Yes, not concerned.
He does not want to defend his case qua 331.
In order to pass that, set aside the orders, when a decree be passed, I will go in execution. If he is found in 331, he will be evicted. If he is not found in 331, he will not be evicted.
Yes,
It is
yes.
as simple as that.
May I see also
What
order
was your
text?
written statement? In your written statement, did you say
Yes.
that you are in 33?
Exhibit 1 Lordship, may kindly see. Exhibit 1, the Dhanbad municipality rent assessment also. Exhibit 1.
Where is the order striking of defense?
Yes, no, that is
16 to 2006.
Then
Lordship, may kindly see Exhibit 1 Lordship.
just
The
अभी
holding
exhibit 1 में बात नहीं, पहले
16 to 2006.
16 to 2000, this is also very much important.
Let us please read this order.
Or can I just read the conclusion or the
पूरा
No,
पढ़िए,
you
पूरा।
read the entire order. Yes, read it.
petition under section 15, one of the Bihar Building Lease Rent and Eviction Control Act 1982 has been filed on behalf of the plaintiff on 21/1/2006 for striking out the defense of the defendant on the ground mentioned therein. The defendant filed its objection as to the petition on 31/2006. Third, it has been stated in the petition that the defendants were directed to make payment of rent in the order dated so and so. The defendant is aggrieved by the said order preferred in the petition before the Honorable Court. The Honorable High Court was pleased to record its observation without setting aside the impugned order while the petition was dismissed. It is therefore stated in the petition on behalf of the plaintiff that the order dated 29/7/2005 remain intact, and since no payment of rent has been effected, as such the defense of the tenant may be struck off. The defendants in reply dated so and so stated that the petition under section 15 BBC Act was filed in respect of holding number 331 of ward number 15 more fully described in the schedule of the plaint by the defendant is in occupation of holding number 332 and is no concern with holding number 331. Her learned counsel for the both the sides and peruse the record of the case. From perusal of the record, it is found that the present suit has been filed by the plaintiff for eviction from suit premises described in Schedule A of the plaint. Thereafter, a petition under section 15 of the BBC Act was filed on behalf of the plaintiff for payment of arrear as well as future rent. The defendant, in pursuant to the said petition, was ordered to pay rent while order dated 29/7/2005. The said order was impugned by the defendant in the petition before the Honorable High Court. The Honorable High Court, while dismissing the petition, observed that the impugned order cannot have any effect on him and no prejudice can be caused to the petitioner.
So default only qua 331.
I am not even claiming 3-3.
Then what happened in the first appellate court?
Yes.
There are concurrent findings.
Perfect. Yes. Kindly have a look at the first appellate.
Is there any finding that they are your tenant?
No, that is against it.
Both the courts said that there is no relationship landlord and tenant between the plaintiff and defendant Lordship.
So far as the relationship of landlord and tenant is concerned, his defense is not struck off to that effect.
But it remains uncontroverted. That's the point.
It does not remain uncontroverted. Everything does not get struck off. It is only what is struck off is the defense against ejectment. He is not opposing ejectment with qua 331.
But then,
He says that he is not your tenant qua 331.
very well, then on the admission order 12, rule 6, it should be decreed, no? That he has no concern with 331. That's the point.
That is the finding. That
No,
there is
that's
no.
not the finding.
Let
That
us
my
see.
suit has been dismissed.
Let us see.
Yes, kindly come to the lower appellate court, sir.
And one thing is also important, plot number and khata number has not been mentioned Lordship in Schedule A Lordship.
The identification will be a subject matter under section 47.
Where is the finding of landlord-tenant
Yes.
relation?
Lower appellate, first appellate court, if you come to page 36 of the
Issue number 3 of the Net High Court Lordship. Page internal page 4, para 7 Lordship.
first appellate court. Now,
अच्छा अच्छा ठीक है
towards page 37, if you lordship comes to running page.
Is 37.
page 37, questions where points of determination is a frame, para 7, whether there is relationship of landlord and tenant between the plaintiff and defendant with respect to the suit property or not, whether the plaintiff appellant has filed an eviction suit in the garb of title suit. These were the questions. Now the finding ultimately.
Para 30.
And
You read para 11,
yes,
10, 11.
10. On behalf of the defendant, 6 witnesses have been examined and they all have denied that father of the defendant number 2, thereafter defendant Bholanath Sinha was ever tenant of the plaintiff. Earlier there was tenancy of holding number 331, but witnesses consistently stated that he left premises in the year 1983 and shifted on holding number 332, which belonged to Hasina Beyoga, and they paid a monthly rent of 250 to her throughout. It has also been stated by defendant witnesses that holding number 331 on Atul Carrier and Transport Company office is situated, which runs its transport business. Though in eviction suit, the court is not required to see the title of the plaintiff landlord, but where the title of the plaintiff landlord has been disputed, then the court may see prima facie title of the parties. Here in the instant case, plaintiff has not found any documents showing that they have got title over the suit property and they are landlord of the defendant. No agreement of tenancy has also been filed. There is also no receipt filed on behalf of the plaintiff. There is also no such witness examined by the plaintiff who ever saw defendant paying rent to suit premises to the defendant. This suit has been filed in representative capacity, but as it is well settled that when a suit has been filed in the representative capacity, the leave of the court, as prescribed in Order 1 relating CPC, has to be taken. The plaintiff at a very belated stage and after conclusion of the argument in appeal has filed assessment list of Dhanbad municipality of holding number 331 and 332, and the said holding, the name of owner has been shown on Madhavji Kara. A correction slip of Dhanbad municipality has also been filed. The said correction slip has been issued on the basis of gift deed, but these municipal receipts and correction slips are not any document of title. They cannot be considered as admissible evidence in this appellate stage. These documents have been filed without leave of the court and cannot be considered as admissible. Plaintiff appellant has also stated the defendant has admitted relationship about landlord and tenant at least prior to 1983, but in view of the settled law, an admission does not create title relationship of landlord and tenant. When defendant has categorically denied the relationship by filing documents, it is also necessary that in eviction suit, plaintiff must establish the relationship of landlord and tenant between him and the defendant, but there is no evidence on record which gives any inference that the relationship of landlord and
Can you hold on? Till this stage, there is no discussion of the evidence of the.
para 10 has to be ignored.
Just a moment.
Para 10 has to be completely ignored.
You see, his defense was struck off only qua 331, right? But once he come up with the plea, and here also, plaintiff appellant has also stated, just see at the bottom, plaintiff's appellant has also stated that defendant has admitted relationship about landlord and tenant at least prior to 1983.
Yes,
Yes.
that's my point. Here we are concerned with the suit property which is situated in 331, not 332. There
That's
is no
right.
schedule there.
So
Right.
at least prior to
So
1983,
therefore there is an admission.
prior to 1983.
Correct.
And that pretty much
Yeah,
is the
please don't be
admitted.
simultaneous. Please don't be simultaneous. Yes.
So let me make my point. So 1983, prior to 1983, he said that I was the tenant.
On 331.
331. Then he said that I have discontinued. So there is no question of the appellate court now getting into a title of the appellant, the title of the plaintiff, because whatsoever, I may be landlord-tenant relationship is there till after 1983. If there is a defense that now I have shifted, that cannot be looked into.
So what has to be looked into? Whether you have proved that he was a tenant in
Now,
in
in
this
the
premises.
facts of this case, it is
Because
very-
on the one hand, you cannot bank upon his admission.
I can.
You can't, because written statement is not there.
That is not his defense. That is his written statement.
This is what you have said. He has admitted that there is a relationship of landlord and tenant. Where is that
Well,
admission coming from?
Then the deny. Very well. I agree. But to that extent, yes, your option may be right that if I can't look into the written statement paragraph 1, then I can't look into paragraph 2
Yes.
with suits for a moment later. But my point here is not whether all these things in view of their claim that I am not in 331, I am in 332. Whether the court could have not said that there is this suit. If it is not, then the court could only have said that there is no case The finding should have been that no, 332 is, but since his defense has been struck off and that entire evidence has not been, could not have been looked into, the court has therefore proceeded in one. Today also I say, if they are saying that they are in 332, let them file, your lordship, let them make an application on compromise. I'll file that very well. You are in 332, 331, the suit is decreed. They have no objection.
There is no question of what kind of compromise you are looking.
No, if they are saying it is not 331, it's 332, then let them
That
file.
is the entire case.
That in that stage can't be looked into. Now, if we can make a joint application, that can be looked into, or else we'll have to contest the case on merits. Because I can't be left like this. With 332, he says that I am not there. So next is para 12 again, notes.
Yes.
Para 12 again, I say no, this could not have been considered. To the contrary, defendants.
Who was his landlord is immaterial.
Hasina.
Forget about it.
Yes.
You forget about it. Who was his landlord?
Correct. Correct.
Right.
Correct.
He says that he is in, and his defense has been struck off only qua 331.
Yes, my suit is only 331. It cannot go to 332. Notes. He cannot be evicted from 332 on the basis of a decree, if at all passed in this case.
So therefore his defense is struck off qua 331, and show me from your evidence that he was a tenant in 331 and he was required to be.
That
Because his admission, his written statement will not be taken into consideration. So you have to show something.
I will have to.
You have to show something that he is a tenant.
So the evidence of my evidence only I can show. Now the only thing you also will have to bear in mind is having regard to the striking of defense. If my oral testimony is also there, unless that testimony is demolished in cross-examination, it will stand.
Certainly it will stand.
And then according to I'll place the evidence.
Place the evidence.
Can I do one thing then? In order to, Lordship, keep it tomorrow or next week. I'll make a small. I'll just,
We have heard it for 1 hour now.
Can
Please
you come tomorrow? I'll just make out a small note of the evidences and come. And it will be over in 10-15 minutes. I have understood the scope of the appeal. You know, I have to satisfy that post 1983, post 1983, before 1983, the two things I
There
want
is
to
no question of any admission. You have to show that he is your tenant. Even if you have a rent receipt prior to 1983, if it is exhibited, the matter ends because his defense that he evicted in 1983 does not stand.
Going by that logic, whatever I have said has not been demolished in cross-examination. It stands uncontroverted, and therefore this is a material which cannot be ignored by the trial court. That's what I'm saying. That therefore.
Where did your tenancy commence according to you?
Specific.
Not there.
Not there.
But
Not there.
para 3 we have said
Not
when he has
there.
defaulted.
Simply not there.
No, it's not there.
Commencement of tenancy is not there. Not even one rent receipt has been exhibited.
But that's what I'm saying. That I can also argue that the admission is not a defense. Therefore, it can be looked into. What has been struck off is his defense against rejection, not an admission. The admissions don't get struck off by virtue of the entire WS. It is not only the defense has been struck off. Therefore, the admission that there was a landlord-tenant
So
relationship
written statement has to be looked into.
for the purposes of admission, to the extent it does not relate to.
It cannot be. Show me that it can be selectively looked into.
It's not a question of select. What has been struck off is defense. It is not that his WS has been expunged. The word used in the statute is striking off of defense qua ejectment. So therefore, what meaning it attaches is that the admissions made
No,
in.
you don't buy this.
No, but the,
Either he will have no right to file written statement.
no, that's not the point. Therefore,
You
that's
cannot pick up admission from his written statement and
I
rely on
cannot.
it.
I can. In fact, I could have, on the basis of this, if there were separate admissions, I could have made an application on 12 for a decree on admission. But this point has to be considered. My submission before your lordship is that his admission is certainly can be looked into, because that has not been struck off. To that extent, it remains intact. Admission and which I could.
And you say that he was inducted in 19?
The plaintiff is silent.
It has not been.
And this person, the plaintiff, he came into picture only in 1994. So he does not have any knowledge as to when he was inducted in as a tenant.
I have said the I'm the
PW1,
yes.
he says that I have come into picture only in 1994.
नहीं PW2 भी है, PW1 तो plaintiff का ये है, PW2 भी, PW2 is there कि प्रतिवादीगण से मैं कई बार भाड़ा वसूल करने के 1984 से प्रतिवादी घोषणा का भाड़ा है, सही से I have given a date May 1984. My point is not that in absence of document it is not necessary that everything has to be evidenced by a documentary evidence. If there is oral evidence uncontroverted, then this evidence is sufficient for me to prove my case. There is nothing which unsettles paragraph 5 of PW.
There is sufficient cross-examination on 332.
But that can't be looked into.
Cross-examination?
It can't be, because cross-examination also has to be confined to my case. And 332, your lordship.
I don't know how selectively you can, you see,
That is what the Supreme
the
Court says.
cross-examination,
That
the
is-
cross-examination has to be, he has a right to cross-examine you.
But not.
But whatever is in your favor is to be looked into, and whatever is against you has to be excluded.
That is what the Supreme Court says.
Does the Supreme Court say that the written statement has to be selectively read?
No,
Does
it's
it
not, a
say-
question, it's not a question of written statement being selected. It's a question of what is to be expunged. What has to be seen into is not, these are not judgments. What has to be excluded is to see. Now, so far as cross-examination is concerned, the Supreme Court categorically said that.
You
we
see, the defense against ejectment is to be struck off on account of default in payment of rent.
Yes.
Right? So far as relationship of landlord and tenant is concerned, that has got nothing to do with the default. That has nothing to do with the default.
It has nothing to do with default.
So therefore, that will not be struck off.
Therefore it is a defense. It is a defense which has to be struck off.
It's so entire. You
Any
see,
defense
if-
with respect to ejectment
just-
has to be struck off.
certainly, if there is a allegation that you were a defaulter, right? Then that defense against that default, because default is a concept. The result is that your defense that you have paid the rent, that will be struck off, right?
That
But so
probably-
far as the claim of landlord-tenant relationship is concerned, that cannot be struck off.
That is also a defense. That a defendant
That is
takes.
not a defense.
That is a defense.
That is not defense against ejectment.
Yes, yes, no. Any defense set up for against ejectment is struck off. That is a defense that you will not eject me because I am not your tenant. That defense has to be struck off. It kindly look at the provision of law. Then I probably will be more clear.
If entire defense has to be struck off, including the title, the landlord-tenant
Yes.
relationship, then what is the big idea of cross-examination?
Only to demolish from the plaintiff's case. It has been clarified. Let's kindly have a look at again at the judgment. This clarifies. I don't think there is any ambiguity in what the Supreme Court is saying on this point. If your object takes it away. The last page. Kindly turn to the last page. We would like to make it clear. We would like to make it clear that the defendant would not be entitled to read any evidence on his own, nor can his cross-examination be permitted to travel beyond the very limited objective of pointing out the falsity or weaknesses of the plaintiff's case. In no circumstances should the cross-examination be permitted to travel beyond the legitimate scope and convert itself virtually into a presentation of the defendant's case either directly or in the form of suggestions put to the
That's right.
plaintiff. So therefore this completely has to be ignored.
You see, nor can his cross-examination be permitted to travel beyond the very limited objective of pointing out the falsity or weakness of the falsity of the case is to be demonstrated by the fact that there is no relationship of landlord and tenant.
That is against his defense. That is not borne out from the plaint. But what is borne out from the plaint? Can I suggest what is the cross-examination which is permitted in a case of this nature?
Yes.
In a case of this nature, the defendant will go and say that, look here, you have said till May 2009, 1984 I was a tenant. Do you have any document? That is permissible. But he can't say, no, in May 1984 you were never a tenant, landlord of mine.
Suppose the defense during cross-examination presents rent receipts.
Yes.
So that will be struck off.
No, that is again rent receipts showing that I have paid.
Showing I have already paid.
I have paid.
That will be struck off.
No, it won't be.
No, suppose
That is the falsity of the plaintiff's case.
So therefore, if the rent receipt issued by the landlord can be exhibited during cross-examination, even if the defense is struck off, so that will go to the falsity of the case, and therefore it is admissible in evidence.
From my case, falsity of the case set out in the plaint. In the plaint, I have said that you have not paid for this month.
Okay.
He goes and says this is your signature.
So therefore, whenever a plaintiff is saying that he is my tenant, and in order to show that this particular plea is false, can he not say that no, I am not your tenant?
Because that is a defense set up on in his WS.
You see, this is also a defense set up in WS that I have already paid the
Then
rent.
I will have to get back to your lordship with more judgments on this point. Can it come to me? Because this, I have my clarity in my mind to what is the extent. I'll get back to your lordship tomorrow. Next week, your lordship will fix. I will.
Tomorrow.
I can do it.
देखिए, for the learned counsel appearing on behalf of the appellant, on behalf of the parties, this appeal has been admitted by order dated 7/2/2023 on the following substantial questions of law. The learned counsel for the appellant, by referring to the judgment passed by the Honorable Supreme Court, reported in bracket 1988 bracket close 4 SCC 619, has submitted that the defense was struck off by the order dated 16/2/2006, and consequently the entire defense, including the written statement as well as the evidences led by the defendants, is required to be struck off. But the courts have considered the case of the defendant while deciding the matter. The learned counsel has referred to the order by which the defense was, the order dated 6/2/2006, by which order dated 29/7/2005, by which the order was passed under section 15 of BBC Act, and the defendant was directed to pay rent 3 years prior to the date of institution of the suit on 4/10/1991 at the rate of ₹250 per month, and also a direction to go on making the current payment. The defense was struck off by the order dated 16/2/2006. The learned counsel for the respondent has submitted that the order dated 16/2/2006 was subject matter of consideration in the petition being WPC number 4683 of 2005. And the specific case of the defendant throughout was the defendant was a tenant under holding number 332 and not holding number 331, and he had a different landlord with respect to holding number 332. He submits that considering this aspect of the matter, the observation was made, though the petition was dismissed, but an observation was made that in view of the statements made by the counsel that the petitioner has no concern with the holding which is subject matter of the suit, the impugned order cannot have any effect on him, and no prejudice can be caused to the petitioner as he does not defend his case with regard to holding number 331, which is the subject matter of the suit. The learned counsel submits that the defense against ejectment qua holding number 331 has only been struck off, and since the specific case of the defendant was that he was in holding number 332, therefore it cannot be said that the defense of the defendant it cannot be said that the defense of the defendant qua holding number 332 was also struck.
And
Yeah, yeah.
one more here, Lord. And both the courts also concurrently held that there is no relationship of landlord and tenant
The learned
between the
counsel
plaintiff
submits
and
that
defendant, Lord.
both the courts have concurrently held that there was no relationship of landlord and tenant between the parties with respect to holding number 331, which was the suit property.
And no tenancy agreement was produced before the learned trial court,
He
Lord.
has also submitted that no evidence with regard to tenancy between the parties qua holding number 331 was produced.
And in
by the
the
plaintiff.
plaint, Lord, the plot number and khata number also are not mentioned, Lord.
None even. But there are holding numbers.
See,
At this, counsel for the appealant submits that he shall
one
advance
more
his
clear
further
subject, my lord,
arguments to
consideration, Lord.
Kalaji.
During the pendency of this case, Lord, the defendant purchased the land by virtue of registered sale deed from the Asina Begum, that is Exhibit E. That is the exhibited documents, Lord.
So, which property did you purchase? 331?
332. 332.
We are not concerned with that.
See.
आइए कर
Tomorrow.
For hearing under order 41/11 item 5, second appeal 44 of 2019.
Before I go with the Eviction, I want to apprise this of the court that there is an IA on the court, that is 63,
आइए number
IA number 6357 of 25.
what is it?
Lord, the respondent, the sole contesting respondent, your lordship, that subsequently, my lord, his heirs were made parties. Now they have also died, and during the pendency, your lordship, the property has been purchased by one, my lord, the purchaser. We have earlier also filed an application to include him as a party. That was subsequently withdrawn, that the vendor will take interest. But now, because he has died, there is no other legal heirs also. So it will be in the interest of justice to inflate them.
They have all died
We have
without any
mentioned-
year.
We have mentioned all this. The lordship may kindly see my interpretation. Original tenant, your lordship, MD Kamal, para 2, your lordship.
Where do you say that there are no legal heirs?
Yes.
Who was substituted?
Substituted was Mustari Begum. His wife. Your lordship may kindly see para 3. Substituted respondent number 3, Mustari Begum, died issues on 3/3/2026 during the pendency of the second. Respondent number 1 was the only contesting respondent in the present appeal, and original respondent number 1, MD Kumar, sold the property to Habibur Rahman, resident of such and such. Subsequently, after the death of Habibur Rahman, his daughter, namely Sabnam, wife of such and such, has sold the premises to Hadi Jafar Nafis Khan. We want him to be included.
Why not Mrs. Shabnam?
Well,
Why not Mrs. Sabnam?
she has sold the property.
No, but Mrs. Sabnam would be the legal here.
No, Sarnam would be is the legal heir of one Habibur Rahman, to whom the former has sold it. Property was already sold Malad during the pendency, but as because he was contesting Malad, so Malad the earlier application, earlier fight was withdrawn, and the Honorable Court of view that vendor is there to protect the interest. They will be stepping in the shoes of the vendor. Now Malad, as because now the original respondent has already died and the property has been sold, and one of the subsequent purchaser in the position, but then it is incumbent on my part to inform further proceeding further.
You see, if you ultimately succeed,
Well,
then he will have his objection at the stage of execution. We don't know.
may have.
He may have an objection. His claim will be tried as a suit.
Then it will be.
We don't want him to be here.
It will give rise to multiplicity.
Maybe no multiplicity. We cannot substitute like this. If she has died issueless, her name will be struck off, and you can argue the case on this.
But in my humble submission, it would be proper that if he pleaded and he right to be dependent should be given. My lord, may kindly see section 4A.
You see, by making him party,
Well,
once he becomes a party,
well,
then under such circumstances, whatever is the judgment passed by this court in this proceeding will be binding on him. Right? If he
even otherwise also binding, because if my lord, he has purchased the property from MD Farmer, then my lord, at best she can take a defense that he is a bona fide person.
he can't take a defense.
Not more than that.
He can certainly take a defense.
That
He will not have an opportunity to file a written statement before this court.
he will not.
What is the suit about?
Suit is landlord tenancy.
Landlord tenancy.
We are claiming that we are landlord. And the original.
By virtue of any agreement of sale.
No, by virtue of my lord, from the original one, our case will achieve that by virtue of my lord, registered bill, that property was bequeathed to us, and thereafter my lord, we have let it out to the original my lord, tenant, that is MD Kumar, and my lord, he in his defense has also filed that no, the one Nasiban Bibi has been given a bill to him, and he has filed a title suit also. That title suit was dismissed, and we were told that no, we are the original ones in that particular suit. So far as my lord, our claim ownership is concerned, it is on a better footing. So far as the landlord-tenant relationship is concerned, for that there is a concurrent finding that there is no landlord-tenant relationship. That I will have.
This IA we will not expand the scope of this. They will have a remedy. They have purchased the property. So from whomsoever they have purchased, whether they have title, no title, we are not bothered about it. Why should we bother about it?
Somebody must be there to contest. Your Lordship may kindly
No,
see.
you see, at this stage, we will only see if there is any
Madam,
substantial
I-
question of law. If there is any substantial question of law, then only we will frame and decide.
My lord, may kindly, just for a moment, your Lordship may kindly see order 22 4A.
For that is- You are not seeking his ejectment, are you?
My lord,
Are you seeking the ejectment of this person who has bought the property?
ultimately he has to be ejected.
So at the stage of eviction, you
Your
will
Lordship
have
may
his
kindly see
remedy.
order 22 4A. My lord, section 12 of the BBC Act, it will cover him. Procedure where there is no legal representative.
Yes.
If any suit, it shall appear to court that any party who has died during the pendency of the suit has no legal representative. The court may, on the application of any party to the suit, proceed in absence of a person representing the estate of the deceased, or may, by an order, appoint administrator general or an officer of the court or such other person as it thinks fit to represent the estate of the deceased person for the purpose of suit, and on any judgment or order subsequently given or made in the suit shall be bind the estate of the deceased person to the same extent as he would have been bound if the personal representative of the said deceased person had been a party to the suit. It is not necessary that he should be thoroughly vetted, but as because he is in possession, and I am myself saying that by virtue of a registered sale deed, he is in possession of that particular property.
If there is no substantial question of law, we will dismiss it. We'll say that so far as IA is concerned, it has got no relevance because there is no substantial question of law is involved. That will serve the purpose. If we frame the substantial question of
They are
law,
already framed.
already framed.
No. It is for admission.
If we frame the substantial question of law, then we will take a call whether we have to make him party or not to make him party. But if there is no substantial question of law, we'll say that he has already died, his name may be struck off since no substantial question of law has been framed. We are not inclined to include anybody as a party.
I agree. I agree.
बताइए. You are the
I am the landlord plaintiff.
yes, please. First read the trial court judgment.
Yes.
Let's see the case of the respective parties,
Yes.
and then we'll
Yes.
proceed with this finding the issue in the findings.
It is para 3 mechanism.
Yes, Bharat.
One, Batulan Bibi was the owner of holding number 115B, block 30D, Jamshedpur, along with the single storied Kacha Mud House. Said holding was allotted to Batulan Bibi by Mrs. Tata Iron and Steel Company Limited for residential purpose from the month-to-month tenancy basis, and the said Batulan Bibi constructed the said house and she was in possession of the same in her own right. The pursued property is a portion of Scheduled A property, which consists of a house consisting of 2 rooms measuring each more than 10 feet to 10 feet with open courtyard. In its west bound north holding 116 of Tisco is in possession of Krishna. The site south Tisco holding number 115 be in possession of Kali. East remaining portion of the same building on holding 140A B block Namta D being half portion of its being in possession of tenants of plaintiff and performer. West Pakka Better Road. Batulan Bibi died in 1947, leaving behind her 3 sisters, who were only near relation, and the next her king, namely Nasiban Bibi, Jharkhand Bibi, Midan, who are all dead. During their lifetime, Nasiban Bibi and Jharkhand Bibi purchased the Scheduled A property from Batulan Bibi with permission of Tisco Limited, and their names were mutated in the office of Tisco and later numbered TAL of 2698/47, dated 1947, was accordingly issued by Mrs. Tisco in favor of Nasiban Bibi and Jharkhand Bibi. A fresh letter of allotment of the said holding of Scheduled A property was also issued by Tisco, while letter number such as. Out of love and affection, Nasiban Bibi, who was the grandmother of Nani of Plaintiff, after obtaining the consent of her legal age, executed a registered will on 6366, bequeathing her half portion of the said holding to the plaintiff, and Jharkhand Bibi also executed a registered will on the same day, with respect to the remaining half portion of the share of the holding to one Raza alias Raza Ali, the pro forma defendant. Accordingly, the plaintiff and the pro forma defendants are in possession over the entire schedule A property with their own right, title, and interest, by letting out the same to the different tenants. Out of the same sisters, only Batulan, Jahiran, and Nasiban and Hamidan, Jahiran and Batulan died issueless. Nasiban died leaving behind only her daughter and the legal heir Latifa, who also died leaving behind her only heir daughter Fatima Bibi, original plaintiff. Hamidan also died leaving behind her only son Putan, who died leaving behind his only daughter Lala, who was legally married to the former respondent number 2, S.K. Raza. As such, the plaintiff would have also inherited the soaked house after the death of the Jahiran, Nasiban and Hamidan, had there been no memo of will as stated by the Nasiban in favor of the tenancy date. The plaintiff required the suit premises bona fidely and in good faith for the personal use in occupation, as the plaintiff is residing at present in the tenanted premises at Adas Nagar Mango, which is about 4 kilometers away from the suit premises of her family member, consisting of her son and his wife, and children have not any other heir, earth or home.
This is on personal necessity.
Personal necessity also and default.
This is area of rent.
Area of rent.
Where is the story of induction of defendant number 1 as a tenant? Nothing has been mentioned as to when defendant number 1 was inducted as a tenant. I could not get it here.
Yes,
This is only regarding the title, whatever we have got.
Para 3C, madam.
Yes. Straight away it comes to bona fide necessity and then it comes to
Here it has come. Areas of rent to such and such. Appellate court has may be permitted to read appellate court.
you just read para 4 of the trial court judgment.
Defendant contested the suit by filing a WS and several legal fees taken for the suit in part of limitation, provision of transfer of property act, Mohammedan law, TR Building Act, provision of section 11, and no cause of action for the suit arises. Defendant filed a suit against the murder of the present plaintiff and the former defendant who were registered as attention in the court of subject, and the same was dismissed as an appeal bearing 6 of 1994, and same is pending before the additional district judge. In view of the pendency of the appeal, it will be continuation of suit with the present suit in partner chamber, as there is every chance of conflict of the decision of same involving both the suits pending in the court of the additional district judge. The defendant denied all allegations and the statement made in the claim, and the claim that they designed for the suit purposes only. It is denied that the wording number 115A B block, Dr. D is 9. But it was never allotted in the name of Batulan Bibi by the school, who had constructed a portion of the building. It is also denied that the Batulan Bibi died in the year 1947, leaving behind 3 sisters. As the relation, namely Nasiban Bibi, Jharkhand Bibi, Hamidan Bibi, during their lifetime, Nasiban Bibi and Jharkhand Bibi purchased the schedule A property from the Batulan Bibi, and their names were recorded in Salista of this limit. Later, they were debarred also. Their defense has been instructed. As a matter of fact, holding number 115A.
Let us see the finding on the point of land. You are concerned with landlord tenant?
Yes. First, I would like to say that this is a case of landlord-tenant relationship, and for that, the focus not admittedly must be on the landlord-tenant relationship itself. My lord, may I kindly see my lord? Issues. Para 5. Para 5 of the trial. It is, my lord, is there any relationship of landlord and tenant? Then, my lord, 4 also, my lord. 3 also, defendant not made any default. Then, my lord, has the premises been bona fide required by the plaintiff? So it is barred by the judicata and the plaintiff is entitled for the remedial. This were the issue. Then, my lord, the discussion that what documents we have brought up. And my lord, as because the defense itself was struck off, as they did not pay the rent under section 15. So, my lord, they were not covered. Issue number 2 and 3, your lordship may kindly see.
2, 3 and 4 were taken up together.
Yes. Relationship and both were taken up together. And after a detailed discussion, failed to establish, getting at page 40. Internal page 40, last paragraph.
Read it.
Yes.
Read it, please.
Yes. As discussed in the previous paras, on the basis of pleadings and evidence available on record, I am of view that the plaintiff has not been able to establish the relationship of landlord and tenant between the plaintiff and defendant, and also could not succeed to prove the defendant as a defaulter in payment. The question of bona fide necessity is also not adjudicated. Accordingly, the issues are disputed. So, adjudicate. 1, 5 and 6 were the finding impact. As discussed in the
Slope
previous
and
manner, the judgment.
The plaintiff's case is that he is in bona fide need.
Yes.
Since there is no relationship of landlord and tenant,
Ah,
there was no need for entering into bona fide necessity.
yeah.
Default का finding
For
आपके
a
against
1, 2, 5, 6 में भी ये
ठीक है, we have seen.
हमारे खिलाफ ही last portion.
What is the finding on res judicata? It was held to be barred by res judicata.
1, 2, 5,
It has been
and
held
6.
to be barred by res judicata. 1, 5 and 6.
Under the circumstances, certainly the suit comes under the purview of section 11.
So it was held to be
And
barred by res
barred
judicata.
and what?
Yes. There was a suit for eviction filed in eviction suit number 21 of 1992, which was dismissed, and mysterious case number 17 of 1993 against that dismissal order was also dismissed. Although there is neither pleading nor evidence where the order of dismissal in
But
this
the appellate
case
court has said that because there was no identification of merit, so it is not barred.
Okay, appellate court says that it is barred, not barred by law.
It is my appellate court finding into that. Not,
Now there are concurrent finding that there is no relationship of landlord and tenant.
yes.
So what is the perversity?
Perversity or worship is that cannot be, despite considering there are no rent receipts, but there is a environment to that effect. And we have brought evidence also. Court has said that on perusal of evidence of oral and documentary, both there is no finding. But when we have brought on governments are here, there is a specific evidence that he was a tenant, he was making payment of rent.
Where is that evidence?
Madam,
Where is that evidence?
that I am reading. Should be kindly seen.
Why have you not brought the rent receipts on record? Rent receipt क्यों नहीं लेके आए?
Rent receipts.
ऐसा आपका केस था कि आप इशू नहीं
हाँ,
करते थे? ऐसा तो केस नहीं है.
लेकिन नहीं आया है देते नहीं.
तो वो लाना था ना?
इसमें देखा नहीं.
क्या देखेंगे? There is no scope. We just can't.
इसका फाइंडिंग पहले हम देखें. My lord, may kindly see internal page number 40. Running page 40. Appellate court level. 40.
Appellate court, Jharkhand 40.
Yes. Internal page 10.
फोर जीरो में तो डिग्री है.
जी. There is some mismatching. It is 38, 39, 40.
I don't know. Internal page बताइए.
Internal page 10.
Internal page 10.
10 out of 10 last में लिखा हुआ. 10.
हाँ ठीक है. बताइए क्या पढ़ना चाहते हैं. बताइए.
PW1 in his cross examination, middle of the third paragraph. First, second, third paragraph. In the suit, plaintiff tried to establish through pleading and evidence that he is the owner of the property by way of will and the defendant is the tenant. Did my lord get?
Yes.
Accordingly, burden shift to plaintiff to prove relationship of landlord and tenant between the defendant. PW1 in his cross-examination in para 46 clearly stated that MD Kumar was his tenant and he has no sheet of paper to establish said, no rent receipt for establishing the fact that he was not. So far as rent receipts are concerned, rent receipts are not mandatory. There is no mandatory that. If suppose I am saying that you are my tenant, I have to establish my tenant. And so far as governments are concerned, oral evidences are there. Oral evidences are there. He has himself said, and he has cross-examined us. He has cross-examined us. Though the defense was struck off, but there is a cross-examination. Then, my lord, may kindly see the finding.
Yes, read it.
My lord, may kindly see last paragraph of the page 10. So far as partial eviction is concerned, neither plaintiff nor defendant has raised. My lord, para second I have already read. Third I would like. In the facts and circumstances discussed above, without any cogent evidence, it cannot be believable that defendant is a tenant. So that the fault is concerned, plaintiff has not been able to bring the chief court paper. Plaintiff has not been able to produce any independent oral evidence. In absence of any documentary or oral evidence is there. That finding is purpose. And apart from that, there is an additional fact which has also been taken notice by the appellate court that I am reading. But there are two portions here. For one portion, I got the premise in a different proceedings. Wherein, in the portion of that schedule, MD Kamal is a tenant by way of additional document I have brought those on the court. Those documents, so far as the degree sheet was concerned, it was before the appellate court has taken note of it. But the judgment was not on board. But by virtue of the judgment and degree passed, portion of the property has already been handed over. One landed court your lordship is granting degree, another landed court your lordship is rejecting the degree, not granting degree, rejecting my claims. And it is not in dispute, your lordship, that so far as their title your lordship is concerned, there was no occasion for the learned appellate court or even for a trial court, particularly appellate court, I would say that to consider all these aspects of the matter. My lord, when a person files a title for declaration of this title, and in that title suit he fails rather, my lord, my title is my lord found correct, then there is no occasion for consideration of all these factors. So far as my ownership or my claim, your lordship, with respect to the premises is concerned, it is not in doubt. Now the question of tenancy, your lordship, is concerned. So far as the tenancy is concerned, there is a specific government, and my lord, I have also, my lord, brought on record, my lord, all documentary evidence, my lord, and my lord, oral.
What documentary evidence on tenancy? What documentary evidence on tenancy have you?
Tenancy not there, but ownership and etc.
Ownership से कोई मतलब नहीं है ना. You have to only see landlord
लेकिन
tenant.
हमने
You
वो-
may be the owner of the property.
वो वाला जो दूसरा वाला जो डिग्री शीट है, जिससे हमें उस पोर्शन के लिए
You
मिला.
see, this landlord tenant relationship is a special legislation.
I agree.
Right? And therefore, there could be a licensee, there could be a trespasser.
But
There are so many aspects of the matter. We do not know. But what you have to prove is landlord-tenant relationship.
I agree.
That's it. You
So-
may be the owner of the property. There may be a will in your favor. Everything is there, but that does not establish the landlord-tenant relationship. And in the second appellate stage, it is not permissible to reappreciate the evidence. No, maybe there is a question of law, but all question of law do not translate into a substantial question
I
of
agree
law.
to that proposition.
Then-
But my lord, may kindly appreciate. So far as the tenancy is concerned, my lord, it is
Yes.
not bar in the law. There cannot be even or there can be oral tenancy.
Yes, there
There is
can
no
be
bar,
oral
no
tenancy.
bar
There
in
is
the
no
law.
bar.
And my lord, if my lord, I have made a specific requirement, my lord, regarding the period of tenancy and my lord, the rent also. And my lord, if that evidence has been brought before the court of law, to which my lord he has been allowed cross-examination also, despite his defense was struck off. And then how can the appellate court my lord come to a finding that there is no evidence of at all? That part your lordship is entirely perverse. And apart from that, your lordship may kindly appreciate for the part of the portion that the possession has already been handed over. There cannot be my lord, two contradictory my lord, judgments, your lordship, on the basis of the same documents. My lord. Your lordship may kindly see those portions, my lord, where the appellate court has discussed it. Your lordship may kindly see, my lord. I would like to read, my lord, page 8 of the judgment. May I read, my lord?
Please do.
May I read?
Page number?
Page number, my lord, 9. During the argument, second paragraph, the counsel for the appellant stated that Exhibit 9 in the warrant to bail for the delivery of possession of the decretal premises passed in the eviction suit number 106 of the 91.
No, we are not concerned with your eviction suit. Why should we be concerned with your eviction suit? There is no question of considering your eviction suit.
Madam?
This eviction suit was filed in the earlier case, no? In the earlier eviction suit. That was ultimately dismissed.
No. This is a eviction wherein my lord, a portion for the portion of the suit premises that has been delivered to me. In the eastern half, my lord, the name of the original my lord, tenant MD Kamar is existing.
So, with respect to the same suit premises, or it is a different suit premises?
No, it is a part of the my lord, schedule A property. I have brought a my lord, this suit.
Your eviction was against a defendant. Did you fight out any other case against a defendant with respect to the same premises?
Lord may kindly appreciate. So far as the schedule A property is concerned, it is a large property.
Okay.
Yes, and my lord, part of the property, your lordship, for the part of the property, my lord, this eviction suit was filed, my lord, title eviction suit number 106 of 91. wherein, my lord, delivery of possession was granted.
So it is the identity must be different.
Madam,
The identity must be different.
suit property is a
Maybe
part.
suit property.
So, no.
See, in one, for the same suit property, there was an eviction suit and it
Your
was
Lordship,
agreed.
may kindly ask you, but there is a schedule A property. Schedule A
You
property
see, the
has
plea
part.
of res judicata
One.
was accepted by the trial court.
That has been reversed. For
That has been reversed, must have been reversed because of the reason
No,
that
no, I am not
I
on res judicata right now.
just don't get it.
Yeah, no.
In the title suit number, in title eviction suit number 106 of 91,
But-
the parties are the same.
This plaintiff was same.
Plaintiff may be same, he must be having 10 rooms. Given to 10 different persons.
Yes, suppose there is a suit property. Part of the suit property wherein I am a plaintiff against a different tenant, that has been decreed to me. I got the
That's
delivery
right.
for this.
But you see, a person may get the status and entry in the suit property, maybe as a trespasser, maybe as a
My case
licensee,
is not.
but
my
unless
case
the
is not of a
relation.
trespasser.
So therefore the
and that
status.
case also is
how-
for a landlord-tenant relationship.
But you have not been able to prove your landlord tenant
So
relationship.
far as the 106 of 91, your lordship is there.
Against third
I was
party.
able to prove not
Maybe
only with all same evidence.
it is not the finding of the court that you are not the owner of the property.
No, I am an owner.
There is no such finding that you are not the owner of the
Your
property.
lordship may continue.
You may be the owner of the property, but when it comes to the relationship of landlord and tenant, the situation is something else.
My lord may kindly appreciate. They filed a title suit. That involvement is there. That is a finding to that effect also. My lord, the defendant, your lordship, they filed a title suit, and in the title suit, our my lord case was found correct. Their will was found to be false. Then, my lord, if that is the true state of affairs, my
Title
lord,
suit number?
yes.
ये तो हो गया। 106 का तो कहानी सुन ली है।
नहीं ये तो I was just reading. It is title suit number 114 of 85. It is in the written statement itself. I am reading para 4 now. One may kindly see para 4. Plaintiff has no valid cause of action. There is no relationship with answering defendant. And answering defendant title suit number 114 was filed by the answering defendant against the plaintiff and Corpana, which was dismissed. So far as our title, your lordship, on the property is concerned, it is established.
Who filed title suit?
Defendant filed.
Where is it? Where is the discussion? कहाँ लिखे हैं इसमें? अब आप written statement पढ़ रहे हैं।
इसमें पारा इनका तो अपना केस है जो पारा 4 तो पढ़े
पढ़िए आप तो बीच में पढ़ना छोड़ दिए तो
हम
क्या
हम
बोलें?
हम पढ़ रहे हैं पारा 4 पढ़ते हैं डिफेंडेंट का केस हम ट्रायल कोर्ट से नहीं पढ़ते
He claimed adverse possession in the title suit. His adverse possession was
No, no,
negative.
he was claiming on the basis of a gift money.
No, whatever it is, although the principal defendant number 1 claimed hostile title against the plaintiff with respect to Schedule A property, which includes Schedule B property, and his claim has been totally negative by the judgment and decree passed in title suit number 114 of 1985.
Yes,
Yes.
that's what I am submitting.
So hostile title was rejected.
Whatever, my lord, he filed a title suit. The basis of claim, your lordship, was the my lord bill, my lord.
Whatever be his basis.
His
So that was-
title suit was dismissed again.
His title suit was dismissed because he was claiming a hostile title against you, and which he could not establish.
My
So,
lord, may kindly appreciate. If, my lord, that is the finding of the learned appellate court, then, my lord, so far as my title, your lordship, is concerned, that will be at least on a better footing, or a much better footing than his title was dismissed. So far as the title with respect to the property is concerned, I'm admittedly in a better position. And so far as the landlord-tenant relationship is concerned, that landlord-tenant relationship, Your Lordship, oral evidences I brought on record, and for the portion of the property in my lord title suit 101, my lord, I got the premises also on the same sets of facts and on the same averments, exactly everything. That has been also considered by the appellate court, but has not properly considered. I was reading it. May I be permitted to read? During the argument, learned counsel for the appellant stated that Exhibit 9 in the warrant of bailiff to the delivery of position of the creditor premises part in eviction suit in favor of the present complaint over plaintiff against the Juveda Khatu, tenant defendant of the suit above eviction number 106 with respect to the portion of this building in which the present suit premises is a portion, and from the boundary that north of the suit premises a portion in the section of another tenant, who is the present defendant. But said argument has not been considered by this court due to the fact that the plaintiff has not pleaded in his plaint and not produced any oral evidence in this regard. This argument is beyond belief. My lord, there is an exhibit 9 on board. That is a decree we have brought on record. And by way of interlocutory application, I have already brought on record, my lord, the judgment itself. So, my lord, for the part of the portion, part of the property, the premises, the proposition was given to us by virtue of a decree. And, my lord, on the same environments and same facts, everything. Exhibit 9, Your Lordship, is a material document for us, which shows that we are not only owner, but a competent court of law, Your Lordship, has given possession to us. In a properly constituted title suit, where all these
The mother of the plaintiff had also filed a eviction suit.
Pardon?
Mother of the plaintiff had also filed an eviction suit.
That was dismissed.
That was also
not
dismissed.
adjudicated on.
Maybe not adjudicated.
But that aspect has been considered by the appellate court, and the finding has given in our court.
That's true.
Your Lordship may kindly see the finding on that. Your Lordship may kindly see para 14 on. Para 14, Your Lordship may kindly see. The appellate court. Now the next point of consideration in this field, whether the learned court below has correctly held that the plaintiff is not entitled for any other relief. On the further perusal of judgment of lower court as a material evidence, below has held the barred by principle of res judicata. In this content, the learned court below has held that Fatima may be filed an eviction on the same ground in the court of Munsif, while evictions which were dismissed and against the said order dismissal, miscellaneous case was filed but said was dismissed. In this content, court is of view that the aforesaid eviction suit and miscellaneous case are dismissed for default and without any hearing in the on merit, hence the eviction suit is not barred by principle of res judicata. That finding is my favor.
आगे पढ़िए.
In this regard, court is of opinion that learned court below has rightly held that plaintiff is not entitled to any other relief for it.
Contradictory नहीं.
res judicata को तो हमारे फेवर में है. res judicata पर हमारा केस इन्होंने डिक्लाइन नहीं किया. इन्होंने मेरा केस इस पॉइंट पर डिक्लाइन किया है कि लैंडलॉर्ड टेनेंट रिलेशनशिप नहीं है और दूसरा कि आपने कोई एविडेंस नहीं लाया. ओरल एविडेंस तो हम लाए. ओरल एविडेंस पे उन्होंने क्रॉस एग्जामिनेशन भी किया. उस ओरल एविडेंस को कह रहे हैं कि कोई एविडेंस ही नहीं लाया. ये फाइंडिंग तो टोटली बर्बाद हो गई. ओरल एविडेंस आर एविडेंस.
Case number 44 of 2019. For the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant submits that both the courts have failed to consider the oral evidence with respect to the tenancy over the suit premises of that of PW1 and have primarily based their finding with regard to landlord-tenant relationship on the ground that no documentary evidence was produced by the plaintiff. She has submitted that tenancy can be proved even by oral evidence, and the law does not require issuance of rent receipt as a condition to prove landlord-tenant relationship. The learned counsel has also referred to IA number 6357 of 2025 to submit that the sole defendant has died on 24/4/2021 and the suit premises is in occupation of subsequent purchaser
Haji Jafar Nafis Khan.
whose details has been mentioned in paragraph 11 of the interlocutory application, and therefore in absence of any legal heir or successor of the sole respondent, the sole contesting respondent, the person who has purchased the property be made party to represent the estate of the deceased respondent. For this purpose, the learned counsel has referred to Order 22, Rule 4, capital A, read with Section 151 of CPC. He submits that the respondent number 1 be deleted and notice be issued. The second appeal be admitted and the notice be issued to the aforesaid person in possession of the suit property whose name has been mentioned in paragraph 11. Having gone through the impugned judgment, this second appeal is admitted for final hearing on the following substantial question of law. Whether the findings recorded by both the courts that there was no landlord-tenant relationship between the parties is perverse on account of non-consideration possible. Non-consideration of the neighbor.
But if some next is there, and if a reasonable man can conclude whatever is being not concluded is a substantial question. Next is there, but it has not been considered in the corporate perspective.
On account of ignoring the oral evidence of PW1 with regard to landlord-tenant relation. And holding that should be sufficient. Let the records be called for from the concerned court.
Exhibit 9 वाला
आइए को notice कर देंगे. Since the estate of respondent number 1, since respondent number 1 has expired as per interlocutory application, तो death certificate लगाए हैं? नहीं लगाए. Let notice be issued to the person named in paragraph 11 of the interlocutory application, so that the estate of respondent number 1 be represented by the person who is said to be in possession of the sole property.
exhibit 9 वाला में भी included.
क्या है exhibit 9?
9 वाला जो degree sheet है, it is a material document.
Exhibit 9 क्या है?
That is the degree sheet with respect to the option of the schedule.
उसका कोई relevance नहीं. We are not implementing that. इसके लिए आप requisite file कर दीजिए. आइए तो अभी अलाउ नहीं होगा. आइए तो नोटिस करेंगे.
Let him appear.
Requisites for service of notice under ordinary process be filed within a period of 1 week. Post on 2nd September, awaiting service.
For record to the special mediation, right? This is item 7, second April 2005 of 2016.
Who's for the appellant? Are you there? Both of you are there? It will be referred to mediation? No?
Case has not been admitted and the property has been vacated by them in a intrusion case.
देखिए. Essay number 205 of 2016. Learned counsel for the appellant has submitted that he is not ready for mediation. Learned counsel for the respondent has submitted that the suit property has already been vacated in execution process, through execution process. In such circumstances, as the appellant is not ready for mediation, the matter cannot be referred to special mediation drive dash mediation within colon for nation. सिंगल इन्वर्टेड कॉमा क्लोज कर देंगे. यहाँ पर रखा हुआ ऑर्डर. चलिए अब क्या है? एडमिट नहीं हुआ है. केस एडमिट हो गया है. तो बहस करिए.
डेट फिक्स कर दीजिए.
कल का डेट. आप कौन?
Tenant, defendant, appellant, appellant.
The case is otherwise ready.
Judgment of adjournment से दोनों को cases of the personal asset in default. Both the ground cases will allowed by the trial court and confirmed by the appeal.
Let this matter be placed tomorrow under the heading Order 41 DT.11.07. There is already a judicial order to that effect. बहस कर लीजिए. Mediation आपको करना नहीं है तो यहीं से decide करेंगे. टाइम मत मांगिएगा, कल DFD कर देंगे, नहीं आइएगा.
Item 8, second appeal 384 of 2017.
I'm making it very clear to you. Don't pray for time. Yes, appellant. Are you ready for mediation? Then, you are representing all the respondents?
Contesting.
The counsel for the appellant and respondent number 1 are present. With the consent of the appearing parties, let this matter be referred to the special mediation drive dash mediation single inverted comma for nation single inverted comma. Office is directly to them.
So before doubts or motion.
हम नहीं जानते कहाँ जाएगा. आप वहीं से पता करें क्योंकि इसमें कुछ लिखा हुआ नहीं है. Office is directed to them.
Item 9, second appeal 499 of 2017.
Yes.
So we are ready. However, this case has not been admitted.
So what? Mediation के लिए कहाँ admission का जरूरत है?
Then we are ready.
Counsel for the appellant has submitted that he is ready to go for mediation. Since this second appeal has not yet been admitted,
Yes, and nobody is appearing.
just a moment. उतना लिखने का जरूरत नहीं है. Article let the matter be placed before second. Obviously.
Item 10, second appeal 256 of 2018.
We are ready to transport medicine.
तो ये same order लिखिए.
Respondent number 1 has died in this case. And we've not been able to seek instruction from our client regarding this. So, there is a device of some respondents.
When did he die?
That we are not aware of information. We have called them. They have said that few of the respondents have died, and they are not willing for the mediation at this stage because
मरा
another
हुआ आदमी is not willing for mediation.
all the legal as they have not been treated as a party. So that's
जी we are referring it for mediation. जिसको भी notice होगा अपने आके बताएंगे कौन legally है या क्या नहीं है.
Earlier we have filed the notice for both proceedings.
Date should be given and chance to file a substitution be given.
You do whatever. We do not know. हो सकता है सारे legal news record में हो. Just take a chance. आप लोग को notice जाएगा आपका देखिएगा क्या करना. Because respondent number 1 had entered by filing wakalatnama.
We are appearing on behalf of respondent, and the legal has, because they have not been included as a party, so they are not willing to go into mediation, and because no substitution has been done in this case as well from the side of the applicants, and there are other few respondents, because there is an array of respondents in this case, and there are other few respondents who have also been died, and to whom they are not
बताइए
appearing on.
other few मतलब कौन few?
There are actually there are 28 respondents in this, and we are appearing on behalf of 1, 3, 4, 5, 6, 7, 8, 9, 26, 27, and 28, and the others who are being represented by other advocates.
The learned counsel for the counsel for the applicant says that he is ready for mediation. The learned counsel for the respondent has opposed the prayer and has submitted that respondent number 1 has expired, who is yet to be substituted, and there are other respondents also who have expired, but he is not aware with specific respondent numbers. He submits that the legal heirs of respondent number 1 has instructed him that they are not ready for mediation. Correct? He undertakes to provide the details of legal heirs and successors of respondent number 1 to the learned counsel for the applicant, so that he may take within a period of 1 week, so that he may take appropriate steps in the matter.
It may be done to 2 weeks. There are numerous respondents.
We do not know.
We have to convey this and get all the resources in terms, please.
Post on 26th August on the appropriate hearing.
Much of it.
आपने तो ऑफिस नोट भी नहीं देखा, आपको कोई मतलब नहीं है. ठीक है.
We are in earlier we have sent the notices, but now we have taken.
कुछ नहीं आता होगा. आगे मर रहा है, जी रहा है, आपको कोई मतलब नहीं. ऑर्नामेंटल हो गया है ये केस आपके लिए.
Item 11, second appeal 308 of 2018.
Actually, this case still has not been handled. So, this is not be this permission notice. This may be read in the proper area.
So are you ready for mediation or not?
No, actually instructions, the clients are not willing, because neither the substantial questions have been framed, nor the admissions have been done.
ये क्या हुआ नहीं हुआ उसकी बात नहीं कर रहे. Are you ready for mediation? Mediation can be at any stage.
Indeed,
Where is the
but-
law that it has to be admitted and then only it has to go for
But
mediation?
they believe that they'll have a much.
Who believe? You also believe the same?
No, Lordship. I believe whatever your leadership will.
No, I just want to know that I'll send it for mediation. Notices will be issued by the authority, and if they appear, mediation will take place, and if they do not,
We'll see in this case a next date, a new date be given, and we'll have the arguments on the admission. Then proper.
not required.
In 41, it is not required in the leadership, I'm aware, but my humble submission would be that the respondents be given appropriate chance for
No,
this.
there is no question. This has not yet been admitted by. We are not here to issue notice. The point is, if the mediator issues notice, or maybe at the pre-mediation stage the notices are issued and they appear, then only the matter can be sent for mediation with their consent. If they don't appear, it will not go. Otherwise, you don't have any objection to mediation. Suppose they want to settle the matter, what objection can you have?
No, Your Worship,
In civil litigation?
No, I should not have an objection.
Essay number 308 of 2018. Counsel for the appellant has submitted that he has no objection if the matter is sent for mediation. Let this matter be referred to who is sent office to do the needful.
Item 12, second appeal 334 of 2018.
Same order.
Item 13, second appeal 367 of 2018.
Who is for the appellant? Appellant absent.
Item 14, second appeal 164 of 2019.
Mediation you will then. Counsel for the counsel for the appellant is present. there is no objection if the matter is referred for mediation. Same order. Why is a notice correct? Why is a pre-mediation notice भी correct? Parties will come, consent होगा तब जाएगा mediation. ऐसा ही हमको समझ में आया.
Item 15, second bill 57 of 2022.
Is appellant? Appellant absent posting.
Item 16, second appeal 72 of 2022.
Appellant absent postponed.
Item 17, second appeal 97 of 2023.
We are ready for the mediation. There are some chances of settlement.
SA number 97 of 23. Counsel for the appellant submits that the matter may be sent for mediation. Same.
Item 18, second appeal 164 of 2023.
Mediation.
Formal KPI pass out clear payments.
Item 19, second appeal 179 of 2023.
Appellant absent postponed.
Item 20, second appeal 190 of 2023.
Send it for mediation.
What's 27? No.
Item 20,
22.
SA number 193 of 2023. Counsel for the appellant submits that the matter may not be sent for mediation. As his clients are not ready for mediation, correct?
No, sir, I mean,
So इसमें कोई नहीं अपील कर रहा है. Counsel absent postponed.
item 21, second appeal 207 of 2023.
Same. Yes.
serial number 18 we are ready for.
Serial number
18.
18. counsel for the at the request of the counsel for the appellant, let this matter be placed before for mediation. Office to do the
Item 22, second appeal 209 of 2023.
at the request of the counsel for the appellant, let this matter be placed before mediation. ये सारे केसेस का समीजी पूरा ट्रैक रखती है, जहाँ मीडिएशन फेल हो जाए बस तुरंत लिस्ट करा दें।
Item 23, second appeal 233 of 2023.
Appellant absent. जितना भी पोस्ट टुमारो हो गया ना सब जगह अंडर द सेम हेडिंग खाली एक केस जाएगा ऑर्डर 41
Item 24, second appeal 243 of 2023.
same order. Appellant absent.
Item 25, second appeal 272 of 2023.
Yes.
Yes, we are ready now, there is no opposite party hearing.
Just at the instance of the appellant, let this matter be placed for mediation. Office to declare.
Item 26, second appeal 287 of 2023.
Are you available?
Yes,
You are representing all the respondents.
Respondent number.
Sorry.
All the respondent has not appeared yet. Not just yet. They have appeared prior to the notice.
Counsel for the appellant and respondent number
2.
are present. At the instance of the learned counsels, let the matter be placed for mediation. Office to declare. Days for mediation में वही term लिखेंगे जो इसमें लिखा हुआ है.
From table list for final disclosure, item 1, first appeal 181 of 2023.
Entry number 181 of 2023. Counsel for the appellant is absent. Mr. Namatai. Mr. Razaullah Ansari is present on behalf of the respondent. Are you there in this case? On 2nd July 2025, nobody had appeared on behalf of the parties, and in order to give one more chance by way of last indulgence, the matter was directed to be posted today. That is was directed to be posted on आज कितनी तारीख है 9?
9.
That today, that is on 9/7/2025. Nobody is appearing on behalf of the appellants, nor any advance notice seeking adjournment has been circulated. Accordingly, this appeal is dismissed for now.
Item 2, second appeal 244 of 2023.
let this order be communicated to facts. ये जिससे arise कर रहा है ना, वो लगा के उसको facts से communicate करो to the concerned court. Yes.
This is not the second appeal by the defendant appellant appellant. By an order number 4 dated 15th January 2025, this appeal has been admitted for hearing and notices were directed to be issued by learned from his appeal appeal. I state that the order which has been passed by Lordship, that is order number 4. The substantial question of law which has been framed in para 4 of the said order, whether the learned court would have decreed the suit without having any issue in connection with the agreement dated 1/4/2008. Why this has come about? Lordship has been pleased to quote the relief portion of the claim. But paragraph 2 of the said order itself. Prayer of the plaintiff, the plaintiff's respondents hearing in package suit number 70 of 2008 was as under. Small a decree for specific performance of agreement for sale dated 27/4/2006 in so far as the defendant number 1 untransferred share of 38.5 decimal of land of Schedule A is concerned, directing the defendant number 1 to transfer 38.8 decimal of untransferred land being the residue share of the defendant number 1 in Schedule A in favor of the plaintiffs or their nominee, there are none covered in terms of agreement dated 27/4/2006, the rate with agreement dated 1/4/2008. Or in case this learned court is of the opinion that the agreement dated 1/4/2008 is not supplement to plot or execute part or extinction of the agreement dated 27/4/2008, rather a separate agreement, then decree for specific performance of agreement dated 1/4/2008 may kindly be passed in favor of Jharkhand Prasad, pro forma defendant number 1, by their transposing him as a plaintiff or otherwise. On the refusal or failure of the defendant number 1 to execute sale deed, transferring residue 38.8 decimal land in favor of the plaintiff and of the pro forma defendant, such deed may kindly be executed by this learned.
What do you say, respondent? The issue never referred to this agreement dated 1/4/2008.
May kindly see written statement para 14 and 14. He did not also admitted the second agreement Lordship. He admitted the first agreement Lordship. May kindly see para 14 and 15 of the.
Okay, but the plaintiff was, you are the plaintiff?
I am the plaintiff. I have
Or
paid.
you are the plaintiff?
I am the plaintiff. I have paid the entire amount Lordship.
You were seeking enforcement of agreement dated 27/4/2006, read with agreement dated 1/4/2008.
But the substantial question has been framed by this honorable court Lordship. The appellant himself not admitted the second agreement Lordship. Where is question for framing of? Let me. Where is the question for framing of issue of second agreement Lordship? May kindly see para 14 and 15. It is very much clear Lordship. And the exhibit 3 Lordship. The deed of disclaimer executed by the appellant himself admitted that he is relying the first agreement Lordship. Deed of agreement.
So according to you, even as per the case of the defendant, there was no relevance of this agreement.
Yes, and the decree has been passed in first agreement Lordship. In first agreement. If your Lordship will see the deed of that is exhibit 3, it will be clear entire matter. And he also admitted that he has paid the entire consideration amount. A suit for a specific performance, the plaintiff has to prove the readiness and willingness. In this case, the entire consideration amount has been paid.
When there is a variance between the parties in the pleading, my learned friend bar again and again saying that the defendants in para 13 and 14 did not admit the existence of an agreement dated 1/4/2008. That there is a variance, and the plaintiff specifically pleaded the plaintiffs that these are the two agreements and therefore the specific relief has been sought for relying upon two agreements. One is dated 27/4/2006, another is dated 1/4/2008. So when there is a pleading and that has been denied and not admitted by the defendant, and there is a variance in the pleadings between the parties, and that is the reason the issues are framed. Issue arises on the variance, not on the admitted point. So when there is a variance, when the specific case of the plaintiff and the alternative reliefs, three reliefs has been sought for. One is based on the first relief, that is on the based upon the agreement dated 27/4/2006, and that too with regard to untransferred share of 38.5 decimal. Again, it was supplemented by another agreement dated 1/4/2008, and then in case, then this is the alternative. In case the learned court is of the opinion that agreement dated 1/4/2008 is not supplement to or put part or in extinction of the previous agreement 27/4/2008. If I pause for a moment, I respectfully submit before your Lordship's consideration that when the plaintiff's own case, that it is based upon 27/4, and if the court does not find favor of the plaintiff in respect of the previous agreement, then the court has to examine the genuineness of the agreement dated 1/4/2008. Then I put a question to myself: in absence of any issue framed with regard to the agreement dated 1/4/2008, how the court will deal with the matter? And at least variance is there. My learned friend is repeatedly and rightly suggested that there was no denial on the part of the, they have not denied, they have did not accept the 1/4/2008, and therefore no issue is required. Issues are framed with regard to the to which the decisions are to be based upon. In the absence of any issue, no findings can be recorded. So the entire matter which has been dealt by the learned trial court in absence of an issue, which is the primary and basic of the suit, and that is the reason your Lordship has rightly framed this question of law. Now for this purpose, your Lordship, I will be permitted to place first of all, the some paragraphs of the plaint and then the WS in order to appreciate the case. Or your Lordship may permit, then I can read out the trial court judgment.
What will be the impact of the subsequent agreement? What is the impact of this?
That is the relief sought for on the basis thereof. And there is a discussion, there is a finding in absence of an issue. That is the crux of the matter. The Lordship may, that is the reason I will be permitted to place the trial court judgment so that your Lordship may appreciate, or I will be permitted to substantiate this point which has been framed by your Lordship. Paragraph 1 note relates to the relief. I am not reading it. Now, para 2. Para 2 of the trial court judgment is the case of the plaintiff. The case of the plaintiff in brief.
You just read para 1.
Para 1. That this suit for a specific performance of contract has been brought by the plaintiffs against the defendant for a DP for a specific performance of the agreement for sale dated 27/4/2006 in so far as the defendant number 1's untransferred share of 38.5 decimal of land of schedule capital A is concerned, directing the defendant number 1 to transfer 38.8 decimal of transferred land, being earlier it is 38.5 and this is 38.8, being the residue share of defendant number 1 in schedule A in favor of the plaintiffs or their nominee Janardhan Prasad in terms of agreement dated 27/4/2006. Read with agreement dated 1/4/2008. So it is part of the suit. Or in case, this is very interesting, in case the court is of the opinion that agreement dated 1/4/2008 is not supplement or part or extension of the agreement dated 27/4/2006, rather a separate agreement, then decree for specific performance of agreement dated 1/4/2008 may kindly be passed in favor of Janardhan Prasad, pro forma defendant number 3, by transposing him. It is also important. Transposing him as plaintiff or otherwise, and on refusal or failure of the defendant number 1 to execute this sale deed transferring residue 38.8 decimal of land in favor of the plaintiff and of the pro forma defendant, such deed may be kindly executed by this landed court in accordance with law. A decree for any other. So, Lordship, permit me, I may submit 3 factors in the prayer itself. Number 1 is specific performance of contract in respect of the previous agreement dated 27/4/2006, by which the defendant number 1, to whom I am appearing an appellant, may be directed to execute this sale of his share, untransferred share. This is first part. Second part, my lord, then in the same relief, in terms of agreement dated 27/4/2006, read with 1/4/2008. So in the relief number 1, the execution which has been sought for, specific performance which has been sought for in respect of firstly 1 agreement, secondly in respect of 2 agreements. This is first part. Second part, in the event the court finds that 1/4/2008 is not a part of the earlier agreement, so the court has to record a finding, and then in respect of 1/4/2008, if it is not part or in continuation or in extension of the previous agreement, then in respect of 1/4/2008, the relief.
The property has been sold out.
I am coming to that. Yes, there are 2 minutes, the case of the
Yes.
land with structures thereon secured by boundary walls more truly such and such. House belong to a hardcore manufacturing unit named and styled as Hindustan Hardcore Company Private Limited, was put on auction by the recovery officer, Debt Recovery Tribunal, DT Ranchi, in recovery proceeding number 170/2002, and 1 Sri Chandan Chakravarti, along with this appellant, made a bid of rupees 10,75,000 to purchase the Schedule A property, having deposited initial bid money of rupees 2,50,000 with the recovery officer and agreeing to pay balance bid amount of rupees 8,25,000 on acceptance of the bid. The bid of the above named 2 bidders, that is defendant number 1 and pro forma defendant number 2, was accepted by the landed recovery officer DT Ranchi, and following acceptance of the bid for auction purchase, the above named bidders were under legal obligation to deposit the balance bid amount of rupees, sale consideration of rupees 9 lakhs within 3 months from the date of acceptance of the bid, within 15/6/2007. But the above named bidders did not or could not arrange funds to deposit the balance bid money and consideration to the recovery officer DRT, so as to conclude the auction purchase and to get this sale confirmed by the recovery officer in terms of provisions laid down under the law. So the above named bidders started looking for potential buyers of Schedule A property who would not only readily agree to buy the said property at a reasonable price, but also pay rupees 8,25,000 as advance within a short notice, so as to enable the bidders to deposit the balance bid or consideration money with the revenue recovery of such DRT. The plaintiffs agreed to purchase the Schedule A property from the above named bidders at the price fixed by them, as well as to pay such sum of money which was required to be deposited bidders with the recovery officer as balance consideration of bid money, so as to complete or confirm the auction purchase in favor of the above named bidder. To show this willingness to purchase the Schedule A, plaintiffs paid a sum of 11,000 the cash to Chandan Chakraborty as advance and later acknowledge the receipt of the other sum as shown in the scheduled payments appended with the check. To facilitate the deposition of balance bid or consideration money with the recovery of such DRT so as to complete and confirm the auction sale, it was agreed between the plaintiffs and the above named bidders that the plaintiffs should pay a part of the agreed sale consideration equivalent to amount of payable by the above named bidders, that is 8,25,000 by demand draft drawn in favor of DRT and deposit the same directly with the DRT and get the sale confirmed therefrom on behalf of the above named bidders. Pursuant to the aforementioned agreement, a formal agreement for sale was drawn up and executed on 27/4/2006, wherein the defendant number 1 and the pro forma defendant number 2 were vendors and the plaintiffs were purchasers, whereby and wherein the above named bidders come vendors agreed to sell the scheduled A property to the vendee for consideration of 19,50,000, and as the dues of the said stipulated consideration, the plaintiffs paid a sum of 3 lakhs by 8 demand drafts drawn in favor of DRT Ranch, the details of which are furnished in the schedule of the payment appended at the foot of the claim, and deposited those 8 drafts amounting to rupees 3 lakhs with DRT Ranchi to be appropriated to the balance consideration payment by the above named bidders. The defendant number 1 and pro forma defendant number 2 duly acknowledge the receipt of advance consideration paid by the plaintiffs to the DRT Ranchi. Thereafter, the purchasers under the agreement on 27/4/2006, the plaintiffs paid a sum of 5,25,000 by several drafts drawn in favor of DRT, detailed in the schedule of the claim payment, and deposited the same sum of 5,25,000 with DRT, and thus the balance bid or concession money was paid by the plaintiffs directly to the DRT on behalf of the bidders, and consequently the plaintiffs paid part consideration of 8,25,000 out of total stipulated consideration of 19,50,000 fixed under the agreement dated 27/2006. The plaintiffs also deposited a sum of 10,760 by draft with the DRT as a bondage money for completion of the auction sale of Schedule A property in favor of the successful bidders, that is the vendors, to the agreement dated 27/2006, notwithstanding the fact that there was no agreement or understanding between the plaintiffs and their vendors, Chandan Chakraborty and Nityanand Bharti, for payment of bondage charge, but considering the fact
See, in the entire case, your specific case was that in case 1/4/2008 deed is not accepted as valid or modifying the earlier deed, then appropriate order in terms of this
This
agreement,
the plaintiff's case.
it is plaintiff's case,
Yes.
right?
So, it revolves around an agreement dated 1/4/2008.
No, it's a
It is not only 27/4/2007, but it also relates to 1/4, because this has been explained why 1/4/2008 has come into place.
Is there any finding that the
Yes, sir.
1/4/2008
Yes,
deed
I'm
is
just coming to that. It will take only 5 minutes, but long reading, speaking word. Then, Your Lordship, I will not read more. Further case of the
we'll
plaintiff.
do it in the second half. उठाइए सर सेकेंड हाफ में आइएगा आज थोड़ा जल्दी 5 मिनट
सेकंड ऑफ पहला शुरू में ही देखा कि
शुरू में ही करेंगे क्योंकि एक डेट केस ऑलरेडी फिक्स्ड है
तो मुझे उसको कल रखना है, एक फिक्स है हमारे लिए 2-15
दिक्कत हो जाएगा।
आपका कौन सा fix है?
ये 20 नंबर को
हमरा
सेकंड अपील
हमारा जो दो पास सवाल लिए हुए हैं जो हम
कल रख दिया जाए
बढ़ाए भी इसलिए 3 बजे तक हम बहुत
या कोई और
Otherwise-
चलिए बहस करिए कोई बात नहीं आप कंटिन्यू करिए
नहीं अभी संभव नहीं है, अभी पूरा नहीं हो पाएगा।
पूरा नहीं हो पाएगा तब कैसे क्या होगा
ठीक है, तो सेकंड के फर्स्ट केस के बाद जो दिया जाए 250 में फिक्स है,
उसके बाद रख दिया
उसके
जाए
बाद रख
हाँ
देंगे
उसके बाद रख दिया उसके
हम
बाद
उतना ही
4
कर-
बजे
हाँ जी
4 बजे
हाँ
उसके
4 बजे
बाद रखते हैं जरा हमको
4
कोई
बजे 4 बजे रख दिए
क्योंकि इसमें भी थोड़ा समय लगेगा जो भी हो 4 बजे
टाइम लगेगा।
एक बात बताइए 1/4/2008 को इशू तो नहीं फ्रेम किया Is the decree based on 1/4/2008?
Yes, I will demonstrate. Otherwise, decree can be, findings can be recorded.
Is the finding based on
Yes, yes.
1/2008?
That I will show. That I will establish. That I will establish. Otherwise, why I should have the lack of this? Entire pleading of the plaintiff is based upon on 2 grounds. One is on the basis of the previous agreement, another by the second agreement. And if there is denial on the part of the defendant or there is a variance in pleading, then issue must be framed.
No. If the issue is framed, Lordship, relating to second agreement, Lordship, in Exhibit 3, he admitted the entire amount has been paid. What order would be passed by the learned trial court, Lordship?
None of us was the
Admitted in the deed of disclaimer, Lordship, the entire amount has been paid.
So what is running in
Entire
the
amount
mind
has
of the
been paid.
trial
This is
judge that we can't expect, which is on the reflected in the judgment. We have to place the judgment. If there is error, I can point it out. If there is no
He
error, you may
admitted the entire
justify.
amount has been paid by the plaintiff, Lordship.
Everything is there, pleading is there, and on the basis of pleadings, issues are framed.
आपको सुन के ना इशू फ्रेम हुआ होगा बिना सुन के तो इशू नहीं फ्रेम हुआ
और अगर इशू भी नहीं फ्रेम हुआ तो मुझे ऑर्डर 14 रूल 5 दिया जाए, देखा जाए
That is the law point.
नहीं
It can be made.
ये एप्लीकेशन दे सकते थे पर फ्रेमिंग ऑफ एडिशनल इशू मगर कोई एप्लीकेशन भी नहीं दिए हैं। ऑर्डर 14 रूल 5
एंटायर केस अगर बेस कर रहा है 1486 का
कोई एप्लीकेशन भी नहीं दिए हैं।
हम एप्लीकेशन दे
framing
रहे
of
थे
additional issue.
इनका जजमेंट ही गलत हो जाएगा, फाइंडिंग गलत हो जाएगा इन एब्सेंस ऑफ इशू. हाउ द कोर्ट हैज रिटर्न द फाइंडिंग इन एब्सेंस ऑफ इशू.
No, he did the admitted that the entire amount has been paid.
साइड बाय साइड मत समझिए आपकी पूरी
ठीक सर, ठीक।
So, उससे कोई फायदा नहीं. ब्लड प्रेशर
अगर मान लीजिए कोई भी फाइंडिंग उस एग्रीमेंट पे बेस्ड नहीं है
तो जो देखेंगे हम देखते हैं फाइंडिंग बेस है उसी पर डिग्री हुआ, छोड़ दे उसको, काम छोड़ दे.
ठीक है हम लोग फिर इसको
फर्स्ट पार्ट जो है उसके बाद रखेंगे.
4 बजे के करीब 4 बजे वैसे तो हम लोग नॉर्मली ऑर्डर्स करते हैं हमारे ऑर्डर्स तो बहुत सारे होंगे लेकिन ऑर्डर्स में जो आदमी ध्यान नहीं देता है केस उसी का केस ऑर्डर्स में चलता है इसीलिए हम लोगों को कोई हड़बड़ी नहीं है
हम लोगों को
रेस्टोरेशन का कोई हड़बड़ी नहीं है ना ही सब्स्टिट्यूशन का कोई हड़बड़ी है लिटिगेंट को होश ही नहीं है हम लोग क्यों अपना दिमाग बर्बाद खराब करें
केस तो जो है ऑर्डर्स में इंपॉर्टेंट है.
कोई तो मेंशन तो नहीं करता है कि इसको टेक
5
अप
बजे
करना
तक बैठते हैं तो भी
नहीं 5 बजे तक नहीं
बैठते हैं, बराबर बैठते थे तो उसमें भी नहीं कंप्लीट.
एक केस डिसमिस हो गया
हाँ, dismiss हो
DFE
गया।
कर दिया गया उसको किसी कल सुन लिया जाएगा
रेस्टोरेशन फाइल करेंगे
कल सुन लिया जाएगा